Everybody, I would like to welcome the members of the regulator, the NESA team, as well as everybody from the public who are joining us on the live stream. We are here today being a special ELS meeting number 262 of the 19th of March in the current year 2026. So I would just like to make one or two announcements before we get into the agenda and the adoption of the agenda itself. We've got here two items that are going to be withdrawn, which is item number 5 and number 6. Item number 5 being the reasons for the decision on Eskom's generation regulatory asset-based redetermination. And then we're also going to withdraw item number 6, application for the market operator license by the National Transmission Company of South Africa. Now, the reasons for that is because we've had a workshop of the ELS where we were looking into these two items. And the workshop felt that, having brainstormed, there's actually substantial areas of enhancements that are still needed before it actually comes to the ELS for a decision. So those are the reasons. So with those reasons and those items being withdrawn, and then of course there's also another item as well on the agenda, which we actually felt is actually a confidential item number 11, which is Eskom and NTSA quarterly data analysis. That one is going to go to the closed meeting for governance. So with that, I'm now going to ask the members to basically, before I'm going to ask the members to, first of all, come in and greet the members of the public. And maybe what we also do as well, as we do that, we just, so that people can see who's talking, I'm also going to switch on my video. As I've said, my name is Willie Majola. I am the full-time regulator for electricity and also a chairperson of the electricity subcommittee. And so I'm also going to call upon other members of the regulator present today to come in to greet the members. I'm going to start with Ms. Maseti. Or maybe we may come back later to end. Ms. Sitole.
Good morning, Chairperson and the members of the ELS, members of NESA staff, or rather staff members of NESA, and as well as everyone who has joined us for this particular ELS meeting. Thank you, Chairperson.
Thank you, Advocate Sitole. And then Mr. Mkize.
Greetings to you, Chairperson, NESA management and staff, as well as the members of the public that are following us through the various live stream platforms. My name is Moses Mkize. I'm the full-time regulator member primarily responsible for petroleum pipelines regulation and a member of ELS. Pardon me that I couldn't activate my camera. It's disabled, but I think the photo does present some kind of representation of myself. Thank you.
Thank you, Mr. Mkize. And then Madam Simani.
Thank you very much. Good morning to you. Good morning to our NESA colleagues as well as members of the public. Thank you very much.
Thank you. Mr. Mabunda, just assist me here. I hope I've not forgotten any other members present today.
Chair, you haven't. I'm struggling as well to find Ms. Massetti. We'll update you as we go, but you haven't missed anybody.
All right. Thank you, Mr. Mabunda, for that. And now with that note, then we are going to move on. With the explanation I gave earlier on that some items are going to be withdrawn for the reasons that it given. So by show of hand, members present, can I see if you are supporting the agenda? Thank you, Mr. Mkize, Advocate Sitole, Ms. Simane, and myself. Thank you very much. So with that, the agenda is therefore adopted. We are now going to go to item number 4, which is the declaration of interests. I think the members are going to submit in writing any declarations, but within the present meeting, if there's any verbal declarations any member would like to raise, then they are open to do so. I do not see any hands for verbal declarations. So we are now going to continue then to the next agenda item, which is item number 7, ESCOM's request for an extension on the temporary amendment to the ferrochrome NPAs. And for that, I'm going to call upon Mr. Matebula and his team.
Chair, good morning once more, and good morning to my NESA colleagues, the members of the board, as well as the people who are following us on live stream. Indeed, Chair, this submission, it's a request for this committee, Chair, to note the request for extension that we received from ESCOM. This was to extend the NPA take-or-pay terms by 12 months. And the original approval, Chair, for this was in August or last year, or this take-or-pay actually became effective in August last year, and it was to expire in January. And on the 14th of January, we received, therefore, a request to have this extended. We took the process of public consultation, which closed last week, Tuesday. We had a public hearing scheduled for Friday last week, the 13th. And Chair, there were no stakeholders who registered for oral representation. And hence, Chair, we proceeded, therefore, to bring this to today's session. I would like to allow, Chair, the people who were leading this project, Ms. Mabinya and Ms. Matlo, to talk to the details and talk to the recommendations as well. And we will also respond to the questions and comments from the members. Thank you, Chair.
Good morning, Chairperson, members and colleagues. Further to what Mr. Matebula has mentioned, to give background, we already have an existing 6-year NPA on this matter. That was approved by NESA in 2023. And then it became effective in January 2024. And when we approved this NPA, there was a condition where these NPAs, there was a condition that was requiring that these smelters must consume a minimum consumption of 70% of their electricity, which is measured over a calendar quarter. And the reason for this condition is to ensure that demand certainty and to ensure that there is demand certainty and to prevent the customers from reducing their electricity consumption during weak market conditions while they retain preferential pricing. And if the consumption then falls behind this threshold, then the customer must pay Eskom. And this condition, therefore, this condition, therefore, is transferred to the contracts between Eskom and this customer, and it's called the take or pay. And as Mr. Matibula has said, that we have this application before us where Eskom is requesting an extension of this take or pay for a period of 12 months to allow the smelters to temporarily suspend their production without really breaching the minimum consumption requirement. And the reason why we've got this application is because the customers are facing market challenges because of Chinese producers that are entering the market with reduced electricity tariffs. And we've had a public participation process, and we've received 2 stakeholder comments, one from an individual and one from Samanco. Both stakeholders support the extension of this waiver. However, the individual supports a 6-month extension instead of a 12-month extension. And another issue raised more especially by the private individual is that the long-term viability of these smelters still remain uncertain, and that some smelters may remain economically unviable even with the waiver. And as a result, they recommend that a broader industry policy consideration beyond the waiver is needed. Stakeholders are also of the view, Chairperson, that future NPA frameworks should accommodate market link hardship triggers. And based on that summary, Chairperson would like to recommend to the committee to note Eskom's request for an extension of the temporary amendment will take up to ER approval of the decision and the reason for decision on Eskom's request for an extension of the temporary amendment to Samanco and Glencore NPA terms for a period of 12 months. Thank you, Chairperson.
Thank you. Now I'm going to open it up to the members if they've got any questions or enhancements or any other contributions. Thank you. Okay, I see Madam Maseti. Let's start with you.
Thank you, Chairperson, for the opportunity, and thank you to Mr. Bavinya for introducing the submission. Chairperson, I've got a specific question to answer to ask, and the question is on this very same request as to whether the what you call the take or pay principle or clause will still be necessary and be required if, for instance, Eskom grants the tariff of 62 cents per kilowatt hour, which we heard from the smelters, very same parties, that this is the tariff level that will be sustainable for them. So the question is, will these go hand in hand? Will they still require that they do not comply with the take or pay principle, as well as still have that tariff level that they believe will be a sustainable one for their business? I think for us, it is important that, yes, we deal with these things in piecemeal, but it is important that there be an assessment of whether these must go hand in hand. There must still be the take or pay principle that is not complied with fully for a period of time, but at the same time, they still get the tariff level that they believe will be a sustainable tariff level. For me, that is an important question that we need to ask ourselves. And also, I think at some point, an exercise that we need to satisfy ourselves that perhaps they need both or they just need one on this. If I can be clarified on that, to the extent that the team has considered this, as we have asked this question before. Thank you, Chair.
Thank you, Madam Masiti. And then Mr. Mkize.
Thank you, Chairperson. Thanks, Madam Mavenya, for the presentation, and Mr. Machegul. I would just like to, just on the analysis of reaching stakeholder comments, my request is that we also respond directly to the issue raised. I'll make an example. When it comes to the extension to the federal commerce matters, let's just be clear with regard to this, and also talk to the fact that it is the policymaker, like the issue that was put forth by the private person, that the policymaker should, from our side, as a first line of regulation of implementation of this, we need to provide feedback to the policymaker to consider an industry-wide dispensation that takes into account also that we are not dealing with a homogeneous whole of smelters. There are various challenges, and some that could still be sustained, not viable. The same with the issue of the 6 months versus 12 months, to say when you're sticking with the 12 months, because we do also have reviews in between, and from a point of view of the stability as requested by the applicant. What I'm not so clear with is on item, it's paragraph, just trying to get to the paragraph, but there's the amount put forth of at 62 cents per kilowatt hour on as paragraph 4.8. Are we having a situation where the waiver of the take-or pay goes together with the 87.74 cents per kilowatt hour, but when the 62 comes in, it will come in, if applied for, where the take-or pay waiver is removed? Just want to get this thing, because the way it is written, if you read paragraph 4.5 going to 4.8, it kind of doesn't come out that clear. That currently we're sitting with the 87.74 cents per kilowatt hour plus a take-or pay waiver, which the industry has spoken about, the 62 cents per kilowatt hour, and that it was intimated that if it comes in, it will come in with the waiver in place. But it's not what we're looking at now. We're looking at the 87.74 cents per kilowatt hour with the waiver. Just that, to be clear in my mind. Thank you.
Thank you, Mr. Mkize. And now Advocate Sitole. Advocate Sitola, or was it a lingering hand?
Sorry, Chairperson, I was muted by mistake. Sorry, Chair. Chair, my question relates to one of the comments made by one of the stakeholders. I think if I heard Ms. Mapinya in her presentation, the stakeholder is indicating that maybe there may be a need to have a framework or policy position to deal with the challenges that are faced by smelters. And I just wanted to find out as to whether will there be a report on how many smelters are experiencing the same or similar challenges than these two that we have. And will this be a report maybe coming to the regulator from ESCOM's side, and such that once it has been assessed, we can maybe support the submission and recommendation to the policymaker for a policy position or a framework that will really be put in place to ease up the challenges that are faced by the smelters. Chair, that is just my point for clarity. Thank you very much.
Thanks, Advocate Sitole. And now I'm going to ask the team to respond. Thank you, team.
Chair, thanks. I hope I'm audible because I received some comments that my volume is a bit low. I do not know why. But if Chair, you don't hear me, you will let me know. Let me maybe start, Chair, and the team will come in and also assist. And I'll start maybe with the last comment, the CEO. Yeah, Chair, we engaged with ESCOM around these matters, and they indicated that it's not only these smelters that are battling, and I must indicate that we have already the TransAlloys also who have now submitted through ESCOM. We have received an application for that too. So it's probably it's currently in circulation to be for the approval processes of the regulator. So they indicated that there are a number of smelters that are battling. However, Chair, the approach by ESCOM has been that it's not all smelters have to go through NPA as a way of dealing with their current issues. So they have had an approach of grouping the smelters in terms of the challenges that each of the smelters are experiencing. And they've also indicated that in their assessment, they had actually established that there were, I think, about 9 smelters that were doing well, or if my memory serves me well. So they indicated that as a regulator, we should expect other applications in the near future, but they are still obviously assessing what other ways these smelters can be assisted, and not necessarily through the NPA processes. So, Chair, I think we can request such information and be able to share it with the members as the current status in terms of the smelters as per the report that ESCOM has currently. I think we can do that, Chair. Maybe it can be a matter arising that we can respond to. Chair, the other matter is on the 62 cent versus 87 cent and versus the take-or-pay. I must indicate that when we were busy processing and finalizing the 87 cent request, the take-or-pay was also submitted. So, and at the time we were at the final stages of considering that first application, which requested the relaxation to 87.74. And Chair, I must indicate that we were made aware that during that application of the 87 cent that the request from the industry or the customers to ESCOM was actually a figure less than that. And the figure that was cited was the 62 that you referred to just now. And the obviously the ESCOM at the time with the proposed to the regulator that they would like to have this figure at 87 cent instead of the 62 that was requested by the industry. And I must indicate, Chair, that ESCOM has also brought to our attention that actually we should be expecting an application on the same matter that actually talks to this 62 cent that was initially requested for. So the take or pay at the time when it was applied to us was applied as an over and above the 87.74 that was already being processed by the regulator. So the take or pay extension was to go with the 87.74. So we do not know at this stage in terms of how the application for the 62 cent will look like when it is brought to the regulator, but I believe we'll assess it as it comes. But I think I just thought I should share this information with the regulator so that when we proceed to the resolutions for this particular item before us, we can at least consider those. Chair, there was a question that was asked in terms of whether the smelters with the 87.74 they still need the take or pay. I think I will ask my colleagues to assist with that, but in terms of from the submission from the utility side, that was what was brought to us or our attention. But in terms of us crunching numbers to be able to justify that, Chair, I think that my colleagues will assist. So that is from my side, Chair. Let me ask maybe Charles and Ms. Mabinya to expand on this. Thanks.
Thank you, Chair. Just to answer the question, as per our understanding, the 87.4 cents tariff, the take or pay is still required because it's not sufficient for some smelters to restart. If we go to the 62 cents, my personal assessment is that we won't need the take or pay waiver, but it can't be reduced overnight because according to the submissions that we had, it will take time for the smelters to get all their furnaces back in operation. Thank you.
Thank you, Mr. Keldad. And now, can I check with the members if they've been answered or if they've got more questions?
From my side, Chairperson, I think if those paragraphs can then be enhanced so they make this point clear, the whole thing of 87.74 cents per kilowatt hour versus the 62 cents per kilowatt hour, and ensure that we don't confuse the situation with the 62 cents per kilowatt hour that has not been applied for. Thank you.
Thank you, Mr. Mkize. And now I'm going to ask Madam Maseti also to come in.
Thank you, Chairperson. Chairperson, I think the matter of the take-or-pay going hand in hand with the 87 cents per kilowatt hour is well clarified. In my view, I think what we need to just make sure that we don't confuse things. The issue of 62 cents is not before us at this moment. So if there is any reference to it, it must simply be what is the desirable the level of the tariff as was previously submitted during the previous application by the smelters. Otherwise, it's not the matter for us to determine. So it is not properly before us at this point. So any reference to it must simply be a reference that seeks to indicate that the smelters are proposing or are, they've suggested that the 62 cents is a desirable amount, not that we must make an assessment of it. I think also the need for having the waiver on take-or-pay is not lost. It will be dealt with through the assessment that will be done if we then get the application for the 62 cents per kilowatt hour. So that's all that I can just emphasize and make a suggestion on in terms of how we deal with these things in the RFDs. Thank you, Chair.
Okay, thank you, Ms. Maseti. Tim, would you like to respond before we go on? You've heard what Mr. Mkiza said. He is supporting it with some enhancements, and then the additional points that Ms. Maseti has put on. Any comments from the team?
No, Chair, I think guidance is taken. We will implement as such, Chair.
Okay, thank you. So with that guidance that you have received from the members, the enhancements, and also the fact that let us not confuse issues, bringing in issues that are not actually before us. So with that, can I then proceed to have a look again at the recommendations, which is to note the request by ESCOM for an extension of the temporary amendment to Samanco Limited and Glencore Mirafic Chrome Ventures Ferrochrome Smelters NPA TOP terms of reference, terms for period of 12 months, which is attached as Annex A. And the next one is to recommend to the energy regulator approval of the RFD on ESCOM's request for an extension. So can I then ask the members if they are in support of those recommendations to raise their hands? I see Mr. Mkize, Madam Simane, Madam Sitole, Madam Maseti, and myself. Thank you. So with that, then we are now going to go on to the next item, which is item number 8, which is NESA rules for distribution to keep registers of their facilities. And again, I'm going to call upon Mr. Matebula and his team. So over to you, Mr. Matebula and the team.
Yeah, Chair, thanks. Yeah, the purpose for bringing this here, Chair, was mainly to have the approval for these rules, which are attached on the submission as Annexure 1, and also to approve the amendment of the distribution forms, which are normally called D forms, and the non-financial information, that document that is also attached as Annexure 2. So, Chair, I think maybe let me ask the the author of the document, Mr. Nechipepe, just to talk to the nuts and bolts of this rule that we have put together, and allow the members to ask questions, Chair. Thanks.
Thank you, Chair. Good morning, Chairperson, members and colleagues. I will take this submission as read. Mr. Matebule has already highlighted the purpose of this submission. This submission is in line with Section 8.1.3 of the Electricity Subcommittee Delegation Matrix that empowers Submission Committee to approve the rules, including regulatory rules on SSEGs. The requirements for the registration of generation facilities was initially derived from the licensing exemption and registration notice that was published on 17 January 2023 in the Government Gazette. This notice mandates the energy regulator to prescribe the manner in which the distributor shall keep a register of any facility with a capacity of less than 100 kilowatt that complies with the code and as a point of connection, and where the distributor has prescribed the condition relating to the continued use of the point of connection. This obligation was further reinforced through the introduction of Section 2A of the Electricity Regulation Act number 4 of 2006 as amended. In response to Section 2A of the ERA, NERSA developed the rules prescribing the manner in which a licensed distributor shall keep a register of facilities with capacity of less than 100 within its distribution areas of supply. NERSA consulted with different stakeholders, namely ESCOM, SALGA, AMEU, to get their views and inputs on the draft rules and deforms. The inputs received were considered and incorporated in both draft rules and revised deforms. The draft rules are accompanied by the deforms and NFI that will capture the location, capacity, type of technology of the facility, amongst other things. The registration of SSEGs facilities is essential to ensure network security, safety of field personnel, protecting the public, as well as to ensure that NERSA has an up-to-date database of installed generation facilities within the Republic of South Africa. I will move to the recommendation. The recommendation I've found in section 14 of the submission on page 6 of 21. It is recommended that the Electricity Subcommittee approves the draft rules attached to as Annexure 1, prescribing the manner in which the distributor shall keep a register of embedded generators with capacities of less than 100 kilowatt as required by the ERA. The amendment of distribution forms and non-financial information attached to as Annexure 2. Thank you, Chairperson. If I didn't cover everything, maybe Mr. Ramugoka can add to what I've already highlighted. Thanks.
Mr. Ramugoka, if you want to add anything.
Good morning, Chair. I think Ms. Nechipepe covered everything that we've done. Thank you.
Thank you. On that note, then I'm going to ask the members if they've got any questions or comments or enhancements. Yes, I see Mr. Mkize.
Thank you, Chairperson. Thanks to Madam Nechipepe and Ramugoka for the presentation. I just don't understand when you go to page 18 of 21 where there's a requirement, for these for documents, right, that would be required from the customers. Are we sure that all these municipalities have got the requisite electricity bylaws, and in terms of providing like for example, the electrical certificate of compliance, and the test certificates. You know, and also if this record keeping, I think the issue of it being up to date as to the when we were to come and ask for it, one would expect it to be up to date at least to 3 months or a month. I just want to understand if those areas have been covered, maybe elsewhere, maybe I miss it. Thank you.
Thank you, Mr. Kize. I don't see any other hands. Oh, okay. I see now Madam Maseti.
Thank you, Chairperson. Chairperson, I just wanted to understand the strategic objective of these rules for keeping the register, especially in view of the regulatory function that we are already implementing, which is in terms of Section 9 of the Electricity Regulation Act, of which section requires the regulator to take administrative decisions by registering these generators. So we are already registering the generators in respect of Section 9. Now, I'm trying to understand the strategic objective of these rules and also stipulating the threshold that we have stipulated herein in these rules that are being proposed. And also just if one were to think about the schedule and that the minister has approved in respect of the exemptions and what needs to be registered. Now, aren't we doing something that, especially when we look at the threshold, is this threshold not going to be in conflict with the threshold that the minister has already imposed in terms of that schedule and of the exemption and the generators that needs to be registered? I'm asking on the threshold first of all, and I'm also asking about whether these rules are absolutely necessary. Secondly, and if they are absolutely necessary, what are the strategic objectives of these rules? If already we are exercising our regulatory mandate that is in respect of Section 9 of the Electricity Regulation Act. For me, those are the three questions that I would like to understand. Thank you, Chairperson.
Thank you, Madam Maseti. And then I'm going to call upon Madam Sitole.
Thank you, Chairperson, and thanks to the presenter. Chairperson, mine is a question relating to the documents that a distributor may require from a customer. And one of the things that's mentioned on page 18 is that there may be a need for the customer to provide verification of an inverter model that they are using, and that inverter model must be among the list that has been approved by the distributor. And the question is, what if some of the customers have installed these inverters prior to the list of distributor, the list that the distributor would have approved? Does it mean that a customer will be required to remove that inverter model, or what would be the situation, Chairperson? And I think also the other point was on the inverter test. certificate, which for me, it's also maybe challenging to a customer to really ensure that those specification standards in terms of the IEC 62116 are there. So I'm just, Chair, just thinking or putting myself in the shoes of a customer who may not really be familiar with some of these tools or processes that are required when they invent some of the things that they're trying to use to really ensure that they get continuous electricity supply. Chair, I'll stop there and just get clarity on the points that I've just raised. Thank you.
Thank you, Advocate Sithole. Can I then ask the team to respond?
Thank you, Chairperson. Chairperson, I'll start with the question that was raised by Ms. Masetti, that what is the strategic objective of developing these rules? Chairperson, you will remember that NERSA has always been registering SSEGs with a capacity above 100 kilowatt, as it is mandated by the notice. The SSEGs below 100 kilowatt, as mandated by 283, NERSA has to prescribe that manner in which the distributor should register these less than 100 kilowatt that were not catered for by NERSA when it registers these SSEGs. So the team is responding to the mandate that is provided by Section 283 to prescribe only what should be in the register when an SSEG is developed and it does have a point of connection. So I would say the strategic objective, there is no general strategic objective, but NERSA is responding to what is mandated in the notice. When it comes to the CEO's question that there's documentations that are required when you have to register your SSEG, and then we have defined the inverters that a licensee can provide. So, Chairperson, we have consulted with the 8 metros. So when we consulted with the 8 metros, the metros, some of the metros had already in their bylaws defined the inverters that are compatible with their networks. And therefore, we took that into account when developing this to ensure that if a municipality has already have a list of inverter manufacturers or inverters that they are compatible with their network, this can also be factored in when a customer does come to register his or her SSE less than 100 kilowatt. When it comes to the capacity of the municipalities, Chairperson, yes, we have consulted with ESCOM, SALGA, AMEU, and the 7 metros that we have done. They all agreed with the clause that says all the distributors that they have that falls into their associations, they are capable of registering. It was noted also, Chairperson, that some municipalities has already started registering, including ESCOM. So in our consultations, we found out that municipalities, with the help of SALGA and AMEU, will be able to register these SSEGs as they develop. Thank you, Chairperson.
Thank you. I also see Mr. Geldart, your hand is up.
Thank you, Chair. I'd just like to come in on this NERSA has had a guideline in this regard, I think from somewhere around about 2010 or 2011, that the municipalities need to register. The big issue with the registration is simply this: you cannot allow a free for all, because the presence of these inverters, if they are able to feed back onto the system, there's a safety issue for 1 point. There's also issues with the ability of the networks to handle it. And thirdly, there's the issue of protecting other customers. One needs to realize that inverters inherently produce a lot of harmonics. And as far as I'm aware, even in the grid code, there's a requirement that the inverters that are installed must comply with the IEC regulations. And the reason for this is because if they produce a lot of harmonics on the system, it's not necessarily the customer with the inverter which will suffer, but it's the other customers that are on the network which will suffer, and they will suffer in which ways. One is to have their electronic equipment damaged, their motors in their fridge motors and other motors failing much faster than they should. There are a number of issues which are critical, and if a free-for-all is allowed and the cheapest inverters are allowed to be installed, then we can start seeing a situation where people are suffering early failures of equipment and electronic equipment, which should not be allowed. We need to protect the other customers. Thank you.
Thank you, Mr. Geldert, for that explanation. And now I'm going to call upon Advocate Sithole.
Thank you, Chairperson. Just a follow-up on the point made by Mr. Geldert on the type of the inverters. I think in as much as, yes, we want to ensure that customers who have these SSEGs and maybe those that live next to them are protected. I think it is important for some of our licensees to ensure that they effectively communicate the required and acceptable inventors, because I do know that this is not done effectively, particularly in the area where I live. I've never seen my metro giving any guidance on acceptable inventors that are going that the community should be using. So I think it is important to ensure that we make it a condition as part of this process that the licensees must ensure that they do disseminate and train customers on what needs to be done, Chairperson, with these SSCGs that are below the 100 kilowatt hour mentioned in the submission. Thank you, Chairperson.
Thank you, Advocate Sithole. Can I also then call upon Mr. Mkhize?
Thank you. I know we're dealing with rules, but maybe it would help, because we've got the objectives of the rules, but maybe just include at the high level the issues that you mentioned as to why we have this in the first place. Because if you are just a ordinary citizen, you easily look at this as maybe some kind of overreach or being unduly prohibiting, or some kind of innovation, So I think it's important that that is stated even in the rules, to give the bigger picture why we're doing what we're doing in this case, and also the requirements from the licensee side must also be clearer. As I said, this issue of bylaws and other matters that you find in some instances the licensees themselves wanting, especially municipalities, that would be a concern for me. So with that, I would then stand to support what has been put before us, with understanding that as the industry evolves, there will be also enhancement with due regard for the need for stability of the sector. Thank you.
Thank you, Mr. Mkize. And then Madam Maseti.
Thank you, Chairperson. Chairperson, firstly, I must appreciate the response from Charles, which has not been captured, the key points. I think he's got about 3 important points that he mentioned regarding the why we are doing this. Because it is one thing to look at what the law says we must do. We must also have full appreciation of what is it that we seek to achieve. Because the law, yes, it will write it where it is written, but there is a policy imperative behind that empowering provision. So that policy imperative must be well articulated. And I think from a practical point of view, one of those reasons are stated by Charles, and they need to be incorporated. That is the first thing that we need to do to improve on this. But it does not end there, the exercise. The exercise must also look deep into what these obligations that we have, or the measures, let me just say the measures that we are proposing in these rules, what those measures would do. Yes, we do what we do, we try to avoid the situation, but in the way that we articulated the measures in these rules, will these measures not result in the owners of these generators being disadvantaged in the market? As we know that there is an issue of imposing a fee, so we need to look into that because it may have limitations for those owners of the generators from competing in the market and getting customers. So we need to look into that aspect regarding the impact of requiring registration. I know that we are not necessarily requiring the fee, but we need to look into what impact will this have for others that are small parties but are providing or connected to the households, customers out there. Will these not prevent them from competing and participating fairly in the market? That is important for me, at least. Secondly, we need to look into the way in which we framed some of these measures in the rules, whether they do not impose undue regulatory burden. I have not heard that we have tested the proposed measures against us, ensuring that we are not imposing undue regulatory burden. As a result, we then impose entry barriers for those small parties or small generators that can service the other customers in the market. That, for me, is the second critical issue on the impact of what we are proposing, what it can do in the market, and that has not been addressed. The third thing that I would like to find out is on process. As you know that before we approve any rules, we develop them as draft rules. Then they come to the subcommittee. Then we make comments and then they get published for comments so that we follow due process that is dictated in terms of Section 10. Now, all I'm hearing is that there were selective consultations, but I have not heard that the matter came to the committee and the committee looked at it and the committee gave a go-ahead that the matter can now go out for public consultation, a broader public consultation, not a limited or selective consultation. Can I be addressed, or at least if we can be clarified, on that issue of the targeted or selective consultation and the process, delegated powers of the committee for approving the draft rules first, so that the draft rules are taken out there for broader stakeholder consultation? To what extent have we complied with those? Those are the third. That's the third question that I have. Thank you, Chair.
Thank you, Madam Maseti. Can I then ask the team to respond?
Thanks, Chairperson. Chairperson, I'll start with the clarity that I want to make that these less than 100 kilowatt SSEGs are your normal customer that installs your PV rooftop panels for own supply. So the notice itself was covering installations that would not be visible to the system operator. So the notice was covering such. So hence it was saying NERSA must just prescribe how the distributor must register these people. So it's a normal customer, a residential customer, or a commercial customer that installs for himself a PV or whatever technology for own supply for purposes of a system operator to see them for technical issues that may arise and safety issues that may arise. So I just wanted to clarify that those are not your generators that participate in a market, or those are not generators that are prosumers. It's only for those who are installing in an area of supply for own use for purposes of being seen by the system op. The reason why we went for this path that we took, we started after reading this section 2A3, we started by amending only the distribution form that will dictate to the distributor what information to keep in the register. We consulted with LAS, and LAS said for anything that we need to prescribe, it rather be in a rule. Hence, we took the path to discuss with the distributors themselves and also took a sample of the 7 metros in developing this document. The reason why we did not use section 10, it was that the prerogative is upon NERSA to prescribe a manner to keep in the register. And we could not necessarily go out on public participation because it was NERSA's discretion and prerogative to define how the manner in which the register is to be kept by our licensee, which is the distributor. Mr. Murati, maybe legal can do that because we had this in consultation with LAS and they advised in that manner previously. Thanks, Chairperson.
Okay, I see Madam Maseti, your hand is up.
Thank you, Chairperson. On this issue of consultation, I don't know whether I must wait for last, but it is not proper because everything that we do in terms of the act that we administer, it is always the discretion of the regulator. And the way that we exercise our discretion, we don't just exercise it outside of applicable legislation and even the Constitution. So we can never say that simply because this is the task. It's just like when licensees are supposed to levy a tariff. Simply because it is going to be the licensees that levy a tariff. Therefore, people that are affected by that tariff must not be consulted. I don't think that statement is correct. Even now, the issue of how they should register, and then now we say that the households that are going to be affected, who are supposed to know what measures we have put in the rules for the distributors and how the household are going to be affected. And then we say that there is no need for us to comply with Section 10. That is completely wrong. It is a constitutional obligation. It is an obligation that is also articulated in PAJA. In addition to PAJA, it is an obligation that it is in Section 10 of our own legislation. There is no way that we can take decisions without making sure that we consult. Section 10 states that very clearly. So we cannot talk about now selective or targeted consultation. It is illegal, and we cannot be led to be taking wrong decisions that did not comply with our own legislation, with the Constitution, and with PAJA. Thank you, Chair.
Thank you, Ms. Maseti. Now I'm going to call upon Mr. Murati.
Thanks, Chairperson. I need to in the ordinary, probably one would have let it slide, but I think I need to put it into the record that the impressions made by Mr. Ramkoka is not the correct advice that was given by LAS in that the development of rules, and as Madam Maseti has correctly placed it, that it needed to be consulted on, not with a limited stakeholder, because they are going to be applicable to the broader society, therefore they needed to be consulted nationally. So the record that has been placed in, it is not correct. We advised contrary to that. Thanks, Chair.
All right. I see Mr. Mkize, the junior.
Thank you very much, Chairperson, for recognizing me. Chairperson, I thought I should also just come in because we did indeed have a bit of a discussion on this particular matter of consultation. In the ordinary course of things, yes, indeed, we should have consulted the general public on the matter. But there were two very pressing issues, Chairperson. The one was that in terms of the interested and affected stakeholders as per the requirements of PAJA, we felt that the stakeholders really that are impacted and affected are the distributors or the municipalities and ESCOM that will need to implement these rules. Of course, there was also a point about the public needing to provide certain information to the distributors, which would have then required their views as well. However, Chairperson, when one looks at the requirements that are listed in the rules, they are very, very limited. Because, for example, in terms of the certificate of the inverter, you know, this is something that comes with the device, and really, you know, it's really important for the distributor to have that particular information for the sake, as Mr. Jaldad was mentioning, that if the inverter is not compliant, it can affect other customers. But we do take the point that we could amend the rules to not talk about a list, but rather to state that the inverter must be compliant with NRS 097 as stipulated in the rules. So Chair, we do take the guidance though, but I must just state that we did try and expedite also the publication of these rules because it really became essential that municipalities and other distributors really need to keep a register of installed rooftop solar and other SSEG installations. But we do take the guidance, Chairperson. Thank you.
Okay, thank you, Mr. Mkize. The junior, I'm going to now ask Mr. Mkize, the senior.
Chairperson, I was maybe misunderstanding because I thought there was a publication and then that is reaching the general public. Then there was specific process, nothing precluding that, where you've got specific engagements with certain parties for assessing valuable information. The fact that we did not engage or did not open this to the general public, because at the end of the day, that information that the municipalities or ESCOM should keep, all the distributors, is actually emanating from the public, the households. And it's also important for them to understand what is required from a municipality and all of that. So they are very much an interested and affected party in this aspect. I would say that let's just get these rules published to enable that aspect to be covered in terms of PAJA. And we'll come back here and have this then address, having incorporated all the comments. That's all from my side. Thank you.
Thank you, Mr. Mkize. And then Madam Maseti.
Chairperson, I think you probably need to provide direction on this issue because it is very clear that the HOD at Legal Services has already provided guidance to assist the committee here, stating clearly that the points that were made here, that the matter is now brought in this manner to the committee, and this has not even been touched on during the presentation on consultation. We must not tolerate anything that is going to expose the energy regulator to legal challenges. There is no way that we can again be found to not have complied with our constitutional obligations when it comes to consultation. The staff must never, ever again bring something here and say, we thought that this and we thought that that. They must not do that. They don't have discretion on that. And they must disclose to these members anything that they've done which is not in accordance with the law. We can't now, we just have had a judgment now against NERSA. We can't have another judgment that says that NERSA, it's a culture where NERSA now is not able, or NERSA ignores the constitutional obligations. It is wrong. So, Chairperson, I would like us to get to the decision part. And the decision part, we will hear from you, Chairperson, where if you want us to amend the decision that is sought from this committee, so that this committee is not made to take a decision that approves rules that did not comply with Section 10 of our own legislation. It is simply wrong, and it must never be brought to this committee. This committee or the energy regulator must never be misled ever again, and we must never find ourselves in court for not complying with stakeholder consultation and give them the opportunity to comment before we take decisions, because the act is clear. Before we take any decision, we must consult with affected parties. I don't think that any staff member must come in now, Chairperson. Members have already stated, legal services have already provided guidance. I think it is up to you, Chairperson, to direct the meeting now so that we get to that stage as to what do we do with this matter that is before us. But as of the final decision on this matter, it cannot be until we follow due process, which we have not followed at this point. Thank you, Chair.
Okay, thank you, Madam Maseti. I think what I'll do now, I'll ask Mr. Matebula, because his hand is up, and thereafter I'll direct the meeting towards decision making. Thank you. Mr. Matebula.
Chair, thanks for the inputs from the members from the time we started presenting this document. But it's clear, Chair, that we have skipped a step in the process. So we will withdraw this matter and bring back a consultation paper, which will be considered by the members for public consultation. Thank you, Chair.
Yeah, thank you, Mr. Matebula. From my side as well, I will support that the matter be withdrawn, simply on the basis that the legal advice, was actually not taken into consideration by the team, when they prepared the submission. I think it creates a problem, for the committee to proceed, knowing very clearly that the submission before it was actually not supported by the legal department. So on that note, that we hear Mr. Matebula himself, who's actually the one who brought the matter to us, that the matter is withdrawn. So may I suggest that we proceed on those lines then, that this matter is going to be withdrawn, and then it's going to be reconsidered outside of this meeting with all the necessary issues before it comes back. But I also see Mr. Mkize as well. Your hand is up, Mr. Mkize.
Thank you, Chairperson. I note that there is a step that has been skipped. And what about clearly outlining that step needs to be executed, and then it comes here? I'm just looking at it from a point of time, unless there are totally no time pressures. Because I was looking at it that here we could be of the view that let the document be enhanced as it was being discussed here, and then they should then go for public consultation. So we don't put another step, they come back here after that and all of that, unless maybe if we are going to follow a round robin route. Thank you.
Look, maybe I will ask for guidance from other members of the committee, but my view would be, let us actually take the thing back to the team, and then let them redo everything, and then we'll have to have another meeting. But let me hear from other members. I saw Ms. Maseti, your hand is up.
Thank you, Chairperson. You've guided properly. And Mr. Matebula acknowledged it. We've got nothing to approve from our side. The way that we approve things, we must have it as a draft. I've already indicated in my comments when I raised the question on process, and that has not been followed. And even with the guidance, it could have been sought even from RSU, because we've got the delegated powers. So before we get to the final approval, which is an administrative action, where we missed a legal step, we will be in trouble. So let us just be careful on that. So you've guided properly, Chairperson. We don't have a sort of a discussion, a covering submission plus draft rules that must then go out for broader stakeholder consultation in compliance with Section 10. We just don't have that. So I do support that the matter be withdrawn. Is not properly before us. Thank you, Chair.
Thank you, Madam Maseti. So, in the interest of time now, I think we need to go on. So this matter is withdrawn. It will be reconsidered by the team, meticulously take into consideration all matters, including public participation, and thereafter it's going to come back to the committee. So on that note, then we are now going to move to item number 9, which is the entry inspection and information gathering outcome report, and it's for.
Chair, apologies to interject.
Sorry?
You summarized the decision. However, you did not ask the members to support it before we can continue. And in that summary, Chair, my understanding of the discussion is that this is withdrawn. The team needs to go work on the consultation paper that needs to come back, not this specific document to come back. The consultation paper that needs to be approved, so it goes to the public for consultation. Thereafter, submission to the subcommittee can be done. My understanding is in that fashion, Chair, unless if I'm mistaken, I may be assisted. But you need to ask the members to vote on the decision.
Thank you for that guidance, Mr. Mabunda. So at this stage, then, I'm going to open it up to the members to vote on the resolution that this matter is going to be withdrawn and that the team must engage the public in terms of the consultation. And once that's all done, they can then come back to the committee. But I also see Mr. Mkize's hand is also up. Mr. Mkize?
No, I'm voting because you are saying.
Oh, you're voting now.
But yeah, but just to be clear, the process is that they come back to us with the discussion document to approve the publication, and then they publish. Then they will then come back as at this stage. That is how the process then should follow. That is why I was saying if there are time pressures to consider still, maybe if there any round robin, if there are time pressures. But you are the FTRM primary responsible, and therefore I respect your position there. Thank you.
Thank you. So we are voting now, Mr. Mkize, then Madam Simane, then Madam Maseti, and myself. So on that note, then the voting is done. And we are therefore going to proceed now to item number 9, which is the entry inspection and information gathering outcome for Cederberg municipality. And I'm going to ask Mr. Matebula and the team once again to take the floor.
Chair, apologies for the background noise. There seems to be activities happening in the area that I'm at. But Chair, this very submission, Chair, was withdrawn from ER, and the issue was that the legal analysis and the recommendations needed to be reworked and reviewed before the matter can be considered. We did experience some delays. This was during the December period. And Chair, we bring this matter back after we have received guidance from ELR. I would request Ms. Ntembu and Mr. Mkize just to give the members the details, and we can consider the recommendations. Thank you, Chair.
Okay, let's hear from the team. 。
Chair,
。
I,
。
I, 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 I,
Chairperson, Ms. Mtembu might be struggling with a connection. But as Mr. Matibula has stated, Chair, the main issue with the submission was primarily around the articulation of the legal empowerments that NESA has with respect to this matter. But Chair, just to maybe highlight some of the other pertinent issues, Chair, we also amended the recommendations to the subcommittee as guided by the ELS. So, Chairperson, we take the matter as having been read and would ask that we maybe read out the recommendations of the submission, which is found on page 12 of the submission, which is to ask the Electricity Subcommittee to note the report on the entry inspection and information gathering outcome for the activities of Clarkson following a request from Cederberg Municipality to ascertain whether Clarkson is conducting its business inconsistent with the ERA. The report, Chair, is annexed to this submission. To also note that the ERA does not provide NESA with the authority to recover lost fees due to Clarkson's contraventions, and that penalties under Section 35B1 of ERA are criminal offences, and any penalty amounts are directed to government revenue funds and not NESA. Chair, we also would like the subcommittee to note that Clarkson's expired license issued by NESA was limited to the operation of a hydro plant and did not include operating solar and wind generators. To also note that the report has established that Clarkson has contravened Section 7A as well as C of ERA, as it is involved in the operation of a 9.42 kilometer distribution network, is trading without the requisite license, and that Chair, NESA has no jurisdiction to invoke Section 18 due to the fact that there is a weakness in enforcement powers in the ERA, particularly where a licensee or an operator rather is not holding a license, Chair. We also would like to note that the subcommittee to note that Clarkson is currently trading electricity at a tariff that has not been approved by NESA, which is in violation of Section 14D and 15 of the ERA, read with Section 2 of the New Generation Capacity Regulations as amended. Chair, we also would like the ELS to recommend to the energy regulator to approve that Clarkson be notified in terms of Section 4B, 2A, AA and BB of ERA to apply for the requisite distribution and trading licenses within 30 days of receipt of the communication, or cease all distribution and trading activities within the same period, Chair. Chair, we also recommend to the energy regulator to approve that NESA sends a notification to Cederberg Municipality as a licensee of NESA that their purchase of generation capacity from Clarkson without complying with Section 34 of ERA and Section 222 of the New Generation Capacity Regulations is non-compliant, and therefore instruct them to make necessary alternative arrangements to ensure electricity delivery to customers, and that end users, Chair, within 30 days. So in other words, the municipality needs to ensure that there is alternative supply in the situation where the other suppliers are not able to supply, Chairperson. We also recommend to the energy regulator to approve that 7 solar farms that are selling electricity to Clarkson be notified that they are in contravention of Section 9 of ERA and that they should apply for the requisite registrations to ensure compliance within 30 days or cease all generation activities within the same period. Chair, we also there's also a recommendation to the energy regulator to approve that a police case be opened against Clarkson regarding the fraudulent generation license that they presented in court and submitted to NESA. And lastly, Chair, to recommend to the energy regulator to approve that the violations of the ERA and new regulations stated in 4 and 5 above should be referred to a tribunal for further regulatory enforcement. So with that, Chair, thank you. And I would like that if Lars has anything to add with respect to the legal provisions, Chair, that they can also, through you, Chair, come in and add to this submission. Thank you, Chairperson.
Thank you, sir. Then, legal, do you want to come in?
Chair, unless Madam Kize has anything to add from our side, there's nothing.
All right. Thank you, Mr. Morati. Then on that note, I'm going to open it up to the members of the regulator to put in any questions or comments or enhancements. Thank you, members. All right, Madam Maseti.
Thank you, Chairperson. At least this matter came to finality because it's important that we make sure that we conduct investigations and inquiries in an efficient manner, particularly where there are issues of substantive non-compliance with the law or contraventions with the law. Unfortunately, this matter has taken long because at the time because there are new provisions in the Electricity Regulations Amendment Act, though some of those legal provisions needed to be thoroughly checked, hence the matter was taken back. But then it took almost 3 months, in fact, 3 months, for it to come back just to deal with that aspect to close the gaps. Otherwise, Chairperson, I think the evidence is very clear, is quite overwhelming, and all of the proof and each of the allegations are well substantiated, in my view. And it was also processed at the ELS, I think twice already, with all of the evidence, and also it went to the ER. It was simply the adequacy of the legal analysis, which was in any event the issue from the start, where the regulator needed to get clarity as to the extent of its mandate and powers when there is no license that is active. And we've got so much of contraventions that have been uncovered. So we hear that, yes, we are let down by the statute, the empowering provisions of the statute. Otherwise, this kind of conduct is punishable. And I'm hoping that we take lessons out of this investigation and will be able to also go to the policymakers and show them that if we don't get provisions of the Act that will make sure that they prevent this kind of a situation and make sure this kind of a situation is punishable in law, then we are going to face other challenges when we get to the SAWEN. Where people will simply not have or obtain authorization through registration by the regulator, or not even having trading licenses, or even getting approval of the tariffs they charge, or even the generators themselves not bothered to come to the regulator to have their operation of generation facilities registered in terms of Section 9, because they know that NERSA will not do anything. And unfortunately, we are in that kind of a situation here. And I'm hoping that we will take action in the sense that we give feedback on these things, so that at least those weaknesses in our law get strengthened, so that we can become an effective regulator and ensure that in the marketplace, everybody will be in compliance with the law. Thank you, Chair.
Thank you, Madam Maseti. Any response from the team?
No, Chair, we note the recommendations of Ms. Maseti, and they will be duly taken into consideration, particularly, Chair, to come back to the ELS to report in terms of all the actions that were recommended for approval, Chair. And I note Mr. Matubula was also coming in at the same time, Chair. Thank you.
Okay.
No, it was the same issue, Chair. Thank.
All right. Thank you very much. Okay. I think at this stage, then we are going to go to voting. I think the recommendations have actually been read already into the record by the presenters. So may I ask by show of hands, members, whether they are in support of the recommendations? Madam Semane, Madam Maseti, Advocate Sitole, and myself. Thank you. So on that note, then we are going to now move on to the next item, which is item number 10, the medium-term system adequacy outlook. Again, we'll call upon Mr. Matebula and the team to take us through this presentation.
Chair, Mr. Chabalala will take us through, but the purpose of the submission, Chair, is to request the subcommittee to note the results of the ESCOM medium-term system adequacy outlook, that is for 2026 to 2030, and also to approve the NERSA report on the same, Chair, as attached on Annexure B. So let me allow maybe Mr. Chabalala to talk to the details, and we can consider the recommendations, Chair. Thank you.
Thank you, Mr. Matebula. Chairperson, the submission that is before us, it's talking to the Matsao 2025 report. I just want to quickly maybe do some correction on regarding the delegation matrix, which is on page number 2 of 90. The clause 3.10 in the paragraph should be changed to 6.3, and I apologize, Chairperson. Chairperson, the purpose of this submission is to request the Electricity Subcommittee to note the results of the ESCOM Medium-Term System Adequacy Outlook 2025 study as required by Section 2.1.2 of the System Operator Code as attached as Annexure A, and to approve the NERSA report on Matsao 2025 as attached as Annexure B. Chairperson, the Electricity Subcommittee is duly delegated as per clause 6.3 of the Electricity Delegation Matrix of 27 November 2025 to approve the NERSA report. Chairperson, Section 2.1.2 of the System Operator Code requires that on or before 30 October of each year, the system operator shall publish a review of the adequacy of the integrated power system to meet the long-term requirements of the electricity consumers. The Matsao 2025 is a 5-year study period starting from 2026 to 2030. And the main input parameters are energy demand forecast, reserve requirements, existing generation capacity, and new generation capacity. The study considered 4 scenarios and 5 sensitivities, and the system is considered adequate when unserved energy is below 20 gigawatt hours, and OCGT capacity factor is below 6% per year. Chairperson, with regards to NERSA analysis, which are captured in the NERSA report attached as Annexure B, the team relied on various documents, including the gazetted IRP 2025.
Can somebody mute?
And Chair, we may proceed.
All right, thank you. The performance of Eskom's generation fleet previously posed the greatest risk to system adequacy, leading to load shedding. However, the EAF recovery program implemented by Eskom has improved performance, resulting in over 9 months without load shedding. According to the power system update shared on the 13th February 2026, EAF has risen to 65.04% compared to 62.78% in October 2025. Chairperson, the system adequacy results for all scenarios over the study period are in Table 3 on page 8 of 90 of the submission, and the accelerated new generation capacity build scenario, which considers a high EAF and 6 gigawatt gas delay sensitivity, brings the system to adequacy from 2026. Chairperson, the recommendations are on page number 9 of 90 and reads as follows. It is recommended that the electricity subcommittee note the results of the Eskom medium-term system adequacy outlook 2026 to 2030 study as required by section 2.1.2 of the System Operation Code attached here to as Annexure A, and approve NERSA's report on Eskom Matsao 2026 to 2030 attached here to as Annexure B. I submit, Chairperson. Thank you.
Thank you, Mr. Chabalala. Can I then ask the members if they've got any questions or comments? No comments, and therefore, can I then ask I see Mr. Mkize, your hand is up.
Thank you, Chairperson. I note what has been presented before us. For example, if one look at, take for example, paragraph 5.16, where you say the committed new and research generation capacity scenario is the worst by far in both unserved energy and OCGT utilization from 2027 calendar year until the end of the study period. Maybe not necessarily here and now, but we should then say, after this analysis, so what in terms of all the processes that should then unfold, either to address the situation or to say what this implies. We look, for example, there's an improvement in the EAF, but not to the level that has were considered in terms of the MIPD determination. What all of these mean, where we discuss maybe in a workshops mode, just to get the implications of all that has been analyzed, and we kind of understand, we have a common understanding around them. that would be my plea with regard to this. This is a lot of information really to digest, but just then to kind of look at the implications and what next. Thank you.
Thank you, Mr. Mkize. Can we get a response, Mr. Chabalala, or your team members?
Chairperson, I note the comment that was actually made by Mr. Mkize, and I must also emphasize that in terms of the what you call the system operator code, we are expected after NTCSA has published the Matsao Outlook to do the analysis. Hence, we've got that Annex B report. But at this stage, I would think that perhaps I would take a guidance in terms of the HOD, perhaps even the EM, just to indicate as to because the what you call the analysis that we're indicating right now, it's information that we are going to also share with NTCSA in terms of our findings. But also I must just bring in another issue, which I think it's important, because when NTCSA is doing this analysis, they normally utilize a simulation tool or a modeling tool, which I would believe that in the future, we need to perhaps look at having something similar that within NERSA we are able to do the very same analysis and perhaps come to an outcome that would either agree or disagree with the outcome that NTSA has actually pronounced. But obviously, with regards to issues that I've mentioned in the MYPD, for an example, on the issue of the EAF, I agree with Mr. Mkize to say, I think in the report, we also flagging that, I remember the MYPD 6 decision, where we pronounced that we need ESCOM to achieve an EAF, if I'm not mistaken, the number was about 70%. And obviously, with the report that it's basically been generated year in, year out, we are able to then track as to what are actually the improvements. And obviously, with the current improvement that we are seeing now, sitting around about 62%, we're seeing that it is possible in the near future to achieve that. But I would perhaps maybe take guidance either from also the EM in terms of, or the HOD in terms of, or even the team in terms of the outcome or the results that we are seeing here, what should actually be the next step the team is actually taking. I will just leave it at here. Thanks.
Maybe can I call upon Madam Makubane first, then followed by Madam Maseti, because their hands are up. Madam Makubane.
Yeah, thanks, FTRM, and good afternoon to the members and colleagues. I probably just wanted to make an attempt at answering the question regarding what the outcomes of the MTCSO is supposed to tell us. Effectively, it's used as an assessment of medium-term risk assessment from a capacity adequacy perspective. It's meant to also feed into processes of the DEE, for example, where Section 34s are made, and it's meant to highlight risks in terms of some of the assumptions that are within the control of either the licensees or the regulator or other stakeholders in the sector. But I think also probably I can highlight that from a performance monitoring perspective of against decisions made in the MIPD6, for example. This analysis can be useful, but there is a process where we need to do that analysis based on the quarterly report, and that submission will be coming to this committee. But just to highlight that the METSAO itself is really meant to highlight risks and bring those to the attention of whether the department or ourselves from a medium-term risk mitigation perspective. Thanks.
All right, thank you, Madam Makubane, and then Madam Maseti.
Thank you, Chairperson. Chairperson, for me, I've got questions that I need to ask, given the medium-term outlook that is before us in terms of adequacy. Firstly, we made a decision in the MYPD6 with regards to the EAF of in fact, the performance targets that the EAF must be at 75%, and we worked on that scenario. And then the second thing was for Eskom, and we asked the specific questions to them, and we said they need to work on the issue of unplanned outages at an operational level. When they motivated for the revenue, they presented to us the generation recovery plan, which needed to improve those technical performance issues at an operational level so that they can also deal with issues that would result into unplanned outages so that they can minimize those and get to expected levels, and so that the EAF level can be improved on. In addition to that, we were generous in the when we allocated the budget for maintenance because of the fact that the strategy that they had in the generation recovery plan was that they really need to improve performance and in fact, by last year, March, they indicated that they would reach 70% by end of March 2025. I am asking myself, what is the team and what is NERSA doing about that? Is that the information that we must just ignore to start off with? And secondly, now that we see this plan, and remember, we're still within the MYPD6 cycle. So now if we are still below 70% and there are no measures that are put in place by Eskom, and we have not even checked the effectiveness of that generation recovery plan with regards to the assumptions that they made before us, so that they can achieve that performance target that we're allowed by law to set, and we have already set it at 75%. Now that they are not achieving it, must the regulator fold its arms and do nothing about it? We are not told now as to this adequacy outlook and the fact that they have not even achieved the set targets. What is the recourse by the regulator under these circumstances? What do we do? We also set a target as to the usage of the OCGTs, that they will not exceed a particular amount. And now that there is no performance on that side, on the coal fleet, then there's compensation by now overutilizing the OCGTs. What are we doing about that? And I'm not getting something that at least would give us a sense as to what is the plan from the regulator, given the fact that the set target of the regulator does not feature at all in ESCOM's plans. The other documents, by the way, that are in the public domain by ESCOM. And the target set by the regulator is completely disregarded. What does that tell us? Because we regulate this entity. We set a target for this entity. And now we've got this outlook that tells us a different picture how the performance is going to be like up to 2030, of which it covers the period of the MYPD. And it is no near the set targets by the regulator. But we are still not told what action the regulator must take in making sure, or what the regulator has done to question ESCOM about the fact that the regulator set targets as required by the law. But these targets are completely ignored. And there are no measures put in place to try and comply with the targets that are set by the regulator. Yet there are costs that the public and the customers must incur. For me, that is the big question. And maybe we need to hear back as this committee, because this is the committee delegated by the regulator, to then hear what has been done by the team to hold ESCOM accountable in terms of performance that is expected from ESCOM, and given the fact that it has not achieved that performance, and also given the fact that even with the forward-looking plans and the outlook of the system, it doesn't look like they will achieve the set targets, performance targets. What measures are they going to put in place? Are they even bothered? Do they even care, or do they completely disregard the targets of the regulator? I am concerned about that, and it is not something, in my view, that we can only deal with at the stage of the regulatory clearing account. It is not that question. It is a continuous monitoring of their performance. Hence, we've got quarterly reports that we must track this kind of performance and what implications and cost implications in particular it will have to the customers. So for me, that aspect has not been addressed in this outlook. And it seems even the team now is ignoring the fact that this outlook comes and it covers the period of the MYPD6. And these are the big issues that we should be concerned about, and what ESCOM is doing about that, and what the regulator is doing about it to take action and ensure accountability, because we entrust ESCOM with the money that comes from customers out there, and we expect excellent performance. We compensate excellent performance by giving them the tariffs. So they must earn that tariff by making sure that they perform. And we did not just come up with a thumbs up figure when we came up with the 75%. We considered it, we justified it. It cannot just be disregarded. And we therefore cannot fold our arms and sit back and do nothing about it. Thank you, Chair. That is my input from my side.
Thank you, Madam Maseti. Okay, Mr. Chabalala, a response.
Thank you, Chairperson. I think I'm just going to attempt, and I take note of what Ms. Maseti has actually cited. Perhaps I must just indicate that the data set that we are actually working with on the Matsau, it's basically talking the issues of new generation capacity, or capacity in general. And my thinking, perhaps Ms. Magubane might come in as well, just to indicate that we are working on a project regarding the quarterly report for the MYPD6. And as I understand, because the data that is going to be submitted for those quarterly reports, it's quite different as you compare it with the Matau. So my thinking is that in that project, we should then be able to respond appropriately with regards to the issue of the EAF, for example. So I thought maybe let me just attempt, but I think Ms. Magubane, if he's available, he can end. Thanks.
Chair, Chair, if I can come in, sorry I didn't raise my hand.
No, it's fine. You can come in.
Yeah. So, Chair, I do not know, but we can be guided. I do not think that the purpose of the analysis of the MTSO was actually meant to deal with the matters that are being raised. But I believe that there are two processes that we are dealing with at the moment. One is that we are analyzing the performance of Eskom based on the reports that they are submitting, and I believe that when Ms. Magubane bring that report to this meeting, I think in the recommendation she will indicate how the performance relate to the current approved MYPD. We are on the first year of the MYPD 6, which comes to an end this month, Chair. And then the second thing, Chair, is that we also approved the SQIs for generation. And in that approval, I think we indicated that the first year of the MYPD will be the testing phase, where we are checking whether there should be penalties or there should be incentives regarding the performance of Eskom. And the same process has been implemented for distribution, transmission, and we recently introduced one for generation. And Chair, yes, on the generation side, I received an appeal from Eskom in terms of the process that we followed, because when we presented the SQI for generation initially at this meeting, we were guided. The process that we had followed was the process of calculating the standard deviations based on the previous year performances to get to what the targets should be for Eskom. I would not know if that was the same principle that was arrived at when the figures were actually put on the MYPD itself when it was approved in January 2025. But we then were guided that we should not follow the process of the standard deviation, but we should focus on the figures that were put on the MYPD. And we did that, Chair. The thing was approved and communicated to Eskom, indicating clearly that at certain levels of performance, penalties will be implemented, and then at certain levels of performance, there will be incentives. So, Chair, for me, I was of a view that it's a process that should that the regulator should enforce, in terms of saying we have got this SQI that we have given to you, and at this point you are performing at these levels, and then these penalties will be applied, and so forth. So that was the other second process that I believed that it will obviously deal with the targets that were put on the MYPD. But I stand to be guided, Chair. Thank you.
All right. Can I call upon Mr. Mkhize?
Yes, thanks, Chairperson. I tried to be maybe economic with time when I said I'm not necessarily expecting this to be ventilated here and now. you do an analysis for a particular reason. You don't stop there, because what is key is the actions that you then take that are informed by that particular analysis. And I understand that there are issues of the system quality, incentives, and all of that. That is still working together with this process. I think to assist on this one, I'm fine with the amendment of the scope, just to clarify that this here you are looking at themselves and the analysis that you have done. Then there will be subsequent reports that deal with actions to be taken in regard of the information that has come out of this himself. That I'm good with. Noting that there are certain positions like the clearing one being the EAF, for example, to say we can't just take what is here and we say we approve. What do we do about it? And my understanding, I tend to be corrected. My understanding is that the SQIs, all this other information that we require from the licensee, aimed at ensuring that when it comes to the process of tariff approval, it's trouble-free, because all of these things as to where we stand as a regulator will also have been made known to the licensee as we go along. If there are some assets that are no longer usable, etc., all those things should come out, making the process easier. This is supposed, because a lot of work is actually in between the applications and the approvals, and not necessarily to then work so hard because now you've got an application before you. That is my understanding, and I'm fine with entertaining what is before us, but just be very clear with the scope and what's still to follow. Thank you.
Okay, thank you, Mr. Mkhize. And maybe if I can just give additional guidance, I think, to the team. My understanding is what we are dealing with here, we've got this medium-term system adequacy report, which ESCOM or the system operator did last year already in November. And if I hear Mr. Mkhize, when he first started, the first time he made a response, he said, yes, we see the ESCOM, the system operator report, it says ABC about the adequacy of the system. But we, as NESA now, so what? What do we say? What are we doing about it? And I think it was also echoed as well by Madam Maseti to say we see things like EAF maybe not going the right way. So what are we saying? But all of those questions are, I think, within the fact that you are dealing with the adequacy of the system. So with that in mind, then, if we gonna say, and maybe what should have happened, because I see there's also an annex as well. Maybe some of these questions like, so what, should have actually been part of the submission itself, where you say in the submission, yes, we've noted that the EAF is not going right, and there's going to be further processes that are going to deal with those issues. So with that understanding, then I would like now to take the issue to a vote to say whether we, as the members, are in support of the recommendations with a view that in future, these reports from the adequacy system must also answer the question that we as NESA, so what are we going to do about the report if we see that there are some areas of non-performance? So with that, may I then ask members to raise their hands if they are in support? I think the recommendation, if I can just remind everybody, it says we the Electricity Subcommittee notes the results of the ESCOM medium-term system adequacy outlook as required by the System Operation Code, which is annexed as Annex A. Secondly, to approve NESA's report on ESCOM MTSAO 2026 to 2030 study attached as Annex B. So may I then ask the members to raise their hands if they are in support of the recommendations?
Chair, what are we approving there, given the fact that we did not do the alignment that is necessary, as you have properly guided even yourself to say, so what, we see this and it's not taking us to where we want performance to be at. So why do we approve? What are we approving? I'm happy to note, but I am not understanding exactly what we are approving when the team has not done risk assessment that is necessary. And that risk assessment should have been aligned properly with issues of, as I indicated, the MYPD in terms of the set targets in the MYPD, as you mentioned also from your side.
So maybe can we then phrase it like this, that we note, I'm looking at 14.1 now. We note 14.1 because it is the result. That is what the system operator has done. We note that result, and then we actually then ask the team to go back and do further analysis to explain to the regulator the actions that we are going to take, for any of the underperformances that were highlighted in the report. Would that work before we vote?
I agree, Chairperson. I don't know if others agree. Thanks, Chair.
All right.
Chairperson.
Yes, Mr. Mkhize.
Chairperson, there are two ways. I'm not necessarily married to any of them. We may insist on that, but at the same time, we may just look at a report as a status report to say, here, this is the status. And then we, as I said, if we vary the scope, what is covered, and here outline that there's going to be a subsequent report that's going to be looking at that, I'm also fine with that. Because you then look and say, these are the things that need to be done, and you just kind of zoom into that more deeply, and which will then be followed up with the engagements also with the licensee and what needs to be done. It helps, and for me, this kind of a report, it helps also to kind of workshop it. I know we've got a lot of things to deal with, making it hard sometimes to make full use of such reports, also in terms of informing ourselves as the regulators, and then being able to to prepare for future decisions that become more enriched because of the knowledge base and the discussions that we've had. Thank you.
Okay, thank you, Mr. Mkhize. So we really need to, I think we really need to move now towards a recommendation. And I see Ms. Maseti again. Maybe before I move to the recommendation, can I allow Ms. Maseti to come in?
Chairperson, I'm making a proposal on the table, and the proposal is that on the first decision, we note that a report from the system operator, and then secondly, we note the analysis that has been done as opposed to approving it. The analysis that has been done by the team, and then we approve that the team must undertake an analysis that involves a risk assessment of what is contained in this report relative to the performance targets that are set in the MYPD6 as well as the SQIs. Thank you, Chair.
Thank you, Madam Maseti. I think then with that, I see Mr. Mkhize.
No, supporting. Sorry.
All right. All right, thank you. So can we therefore go to vote? I'm not going to repeat now what Madam Maseti has said as a way forward in terms of the proposals. Let us vote based on what Madam Maseti has said. And so I see Madam Maseti, Madam Semane, Mr. Mkize, and myself. So on that note, then,
Madam
thank you
Sithole as well.
Oh, sorry, Madam Sithole. No, thank you very much. So thank you very much, Tim. We are now going on to the point where we are going to go to a closed meeting, and therefore I would like to thank all the members of the public that participated through the various platforms. It is very, very important for the public to be involved, and we really, really appreciate your involvement as the members of the public. So on that